Welcome to the deep dive. This is where we take complex subjects, grab the most insightful source material we can find, and really drill down to extract the crucial knowledge.
Yeah, our mission is basically to give you the core understanding, those key insights, without you getting lost in all the jargon.
We're kind of your guides, helping you get truly well-informed, but, quicker.
Exactly. Connecting the dots, making sure the big ideas stick.
And today we are diving deep into something absolutely foundational if you're grappling with English contract law. We're talking about consideration and a really crucial related concept, promissory estoppel.
Oh, absolutely fundamental. These two ideas are, well, they're often the gatekeepers, determining if an agreement, once you've got offer and acceptance sorted, is actually enforceable in court.
So they decide if it's just talk or if it's legally binding.
Pretty much, yeah. They add that layer of legal seriousness.
Now, for this deep dive, our source material comes from some really invaluable documents made available by the University of London. These are provided for educational purposes for students, and honestly, we're so grateful for them. They give us such a solid foundation.
They really do. And we should also mention, this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
And, we know a lot of you listening might be students, perhaps even getting ready for exams right now.
Definitely. So we just wanted to say, genuinely, the very best of luck with that. Hopefully our chat today helps clear up some of these sometimes tricky areas.
Yeah, fingers crossed this helps. So what's the plan? We'll start with the basics. What is consideration? Why do we even need it in English law?
Right. We'll unpack the definitions, look at what the courts actually recognize as valid consideration, what they call sufficient consideration.
And then tackle some of the trickier bits, like existing duties.
Exactly. How performing a duty you already have fits in. That's a big one. We'll touch on past consideration, too.
And then we pivot to promissory estoppel. What is it? Why did it develop?
Yeah, it's this equitable idea that came about because, frankly, the common law rules on consideration could be a bit rigid. We'll see how it works, its limits, and how it interacts with consideration, especially when you're changing a contract.
And we'll be using specific cases and examples from the University of London materials all the way through just to make it concrete.
It's a journey, really, from the basic need for exchange to how equity steps in to ensure fairness. Shall we jump?
Let's do it. Okay, first big idea. What exactly is consideration? You called it the gatekeeper of enforceability. Can you expand on that a bit?
Sure. So imagine you've got your offer and acceptance. The parties have agreed on something. Consideration is the next legal hurdle at common law. It's the main test the courts use to decide if that agreement should be legally binding.
So without it, even if we clearly agreed, I probably can't sue you if you back out, generally speaking.
That's the crux of it, yes. Consideration brings in this vital element of mutuality or exchange. For an agreement to become a binding contract, each party has to give something or promise something in return for what they're getting.
Okay, so it's the something for something.
Precisely. That's something moving from each side. That is their consideration. You could call it the price paid for the other person's promise.
That kind of makes sense intuitively, doesn't it? Like, if I just promised to give you my old laptop next week, just out of the blue, and you haven't promised anything back.
Well, it feels like a nice gesture, but not something I should be legally forced to follow through on if I, say, change my mind.
And usually you wouldn't be. A bare promise, a promise to make a gift in the future with nothing coming back the other way, isn't typically enforceable in English law. It lacks consideration.
Is there any way around that? Well, the main exception is if you put that promise into a very formal legal document called a deed. Deeds have specific requirements, under laws like Law of Property, Miscellaneous Provisions Act, 1989. But for your average, everyday agreement, you need that exchange.
It's interesting. The source mentioned that historically, consideration also sort of showed the parties intended to be legally bound. Like they weren't just having a casual chat.
Yeah, it kind of pulled double duty back then.
Yeah.
Nowadays, we look at intention to create legal relations as a separate thing that's covered elsewhere, I think Chapter 4 in the materials. But that historical link shows just how central consideration has always been.
And yet, it's not always applied rigidly. The source suggests there's been some flexibility.
Oh, definitely. And that's important to remember. As we'll see when we get into the cases, especially the more modern ones, the courts have had to adapt it a bit to, well, how business actually works.
Okay, let's use that simple example from the materials. A promises to paint B's fence.
Right. So A's promised to do the painting. That's A's consideration. But for this to be a contract, B needs to provide something too.
like promising to pay A, say, £100.
Exactly. If B promises to pay £100, that promises B's consideration. You need both sides giving something A's promise to pay and B's promise to pay. That's what makes it a binding agreement.
Got it. It's the two-way street. Something from me, something from you.
Precisely. And this naturally leads us, just briefly for now, to the idea that sometimes, just sometimes, a promise can be binding even without that classic common law consideration. That's where promissory estoppel comes in.
Ah, the equitable backstop.
Yeah, we'll dig into it later, but it's basically the law finding ways, through equity, to protect someone who reasonably relies on a promise, especially when you're varying an existing deal, even if no new consideration was technically given for that change.
Okay, so our goal then is to really get to grips with what consideration is, what its limits are, especially in those tricky areas, and then figure out how promissory estoppel works alongside it, or sometimes instead of it.
Right, which covers all those key learning outcomes mentioned in the source material, the definition, why it matters, what counts as good consideration, those existing obligations, past consideration, modifying contracts, and of course, promissory estoppel itself.
It sounds like a thorough workout for understanding how promises become enforceable.
It is. Let's get into the nitty-gritty now.
Okay, Section 2, defining consideration in more detail. You called it the badge of enforceability, especially for future promises.
Yes, because when we're talking about promises to do things down the line, consideration is what tells us if that promise has legal teeth. And it's helpful here to distinguish between two types, executed and executory consideration.
Okay, executed first. What's that?
Executed consideration is where the act that forms the consideration is performed right at the time the agreement is made, or very soon after. Think about buying a coffee. You offer the money, the barista gives you the coffee.
The exchange happens there and then.
Exactly. Your act of paying is your executed consideration. Their act of giving the coffee is theirs. It's done, completed, executed.
Simple enough. So what's executory consideration?
This is where the parties exchange promises to do things in the future. For example, I promise to deliver you 100 widgets next Monday, and you promise to pay me £1,000 upon delivery.
So when we make that deal, neither of us has actually done anything yet.
Right, we've just swapped promises.
Yeah.
My promise to deliver is the consideration for your promise to pay, and your promise to pay is the consideration for my promise to deliver.
The promise itself is the consideration.
Yes, and this is where the traditional definition gets interesting. The famous one comes from Curry v. Mesa, 1875. It says, valuable consideration may consist either in some right, interest, profit, or benefit accruing to the one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other.
Benefit to one party or detriment to the other, so either will do.
Yes, either is sufficient. When someone performs an act, like painting the fence, it's usually a detriment to them, time, effort, paint, and a benefit to the other. Nice fence.
Yeah.
That's easy.
But with purely executory contracts, just promises, analyzing it strictly as benefit-detriment before anything happens feels a bit abstract. It can feel a bit circular, yeah. Which is why some argue it's maybe more helpful for executory contracts to just think about it as the requirement for mutuality, or the exchange principle. Did each side offer something in return for the other's promise? If yes, that exchange itself makes the promises binding from the get-go.
Okay, the fact of the reciprocal promises is the key. Let's talk about a specific kind of detriment that counts. Forbearance to sue. What's that about?
Right, this is important. If you genuinely believe you have a legal claim against someone, maybe they owe you money or they damaged your property, your promise not to pursue that claim, to forbear from suing, can be good consideration for a promise they make to you in return.
Like if they promise to pay you a certain amount to settle it. Exactly. As long as you asserted your original claim in good faith, even if maybe your claim wasn't legally perfect and might have failed in court, if you genuinely believed you had a case, giving up the right to pursue it is seen as a detriment to you and a benefit to them. They avoid the hassle and risk of court.
What cases support this?
Cook v. Wright, 1861, is a key one, and it was confirmed more recently in Simmental v. Shavli in 2019. The benefit to the party not being sued is clear they're free from defending the action.
But what if I know my claim is completely bogus? If I threaten to sue just to pressure someone?
Well, that's where Wade v. Simi in 1846 comes in. If you know you have no valid claim, your promise not to pursue it is not good consideration. The law won't support using baseless threats to extract promises. It's about preventing, well, essentially fraudulent claims from being rewarded.
Makes sense. Okay, another really fundamental rule. Consideration must move from the promisee. What does that mean?
It means the person who wants to enforce the promise must be the one who provided the consideration for it. You can't enforce a promise made to you if the consideration for that promise was actually provided by someone else entirely.
So, if Dad promises to pay me £100, if my uncle gives him £100, I can't sue Dad if he doesn't pay me because I didn't give Dad anything for his promise.
That's the principle. The classic case is Tweddle v. Atkinson. There, two fathers agreed, essentially with each other, to pay money to the son upon his marriage. One father died without paying, and the son tried to sue the estate.
And he lost.
He lost.
Yeah.
The court said the son couldn't enforce the promise because he hadn't provided any consideration for his father-in-law's promise to pay him. The consideration had moved between the two fathers.
This sounds very similar to the idea of privity of contract. Only parties to the contract can sue on it.
It's very closely linked, yes. Tweddle v. Atkinson is often cited for both principles. Privity is a whole other topic, Chapter 11 in the materials, apparently, but the overlap is strong here. The person enforcing promise must have given the consideration.
Let's quickly run through those window cleaning examples again. Activities 3.1 to 3.3, Activity 3.1. B cleans A's windows. A promised £30. B's consideration.
B's act of cleaning. Executed consideration. It's a detriment to B, work, and benefit to A, clean windows.
Activity 3.2. A pays B £30 up front. B promises to clean next Tuesday. Consideration for B's promise.
A's payment. Executed consideration from AB provides their promise to clean executory consideration.
Activity 3.3. A promises £30 on completion. B promises to clean next Tuesday. D doesn't show. Breach.
Yes, definitely a breach. It's an executory contract. A's promise supports B's promise. B's promise supports D's promise supports A's promise. Binding for the moment they agree. B's failure to perform breaches that binding agreement.
Okay, those examples nail down the mechanics. Now on to something that often confuses people, sufficiency versus adequacy of consideration.
Right. These sound similar but are legally quite distinct. Sufficient means, is it something the law recognizes as having some value? Is it the kind of thing that can be consideration?
Like money, goods, services, a promise.
Exactly. Whereas adequacy refers to the amount of value. Is the exchange fair? Is it a good bargain?
And the massive rule here is consideration must be sufficient, but it does not need to be adequate.
Absolutely critical. Courts check if something legally valid was exchanged, but they generally won't get involved just because one side seems to have gotten a much better deal than the other. Freedom of contract means you can make a bad bargain if you want to.
The classic case is Thomas v. Thomas, 1842, isn't it? The widow paying £1 a year rent.
Yes. The husband's executors let her live in his house after his death, in line with his wishes, provided she promised to pay £1 per year and keep the house in repair. The executors later tried to argue it wasn't a real contract, just a gift motive.
But the court disagreed.
Yes, they held her promise to pay £1 annually and maintain the property with sufficient consideration. Paying money, even a nominal amount, and taking on an obligation to repair are things the law recognizes as valuable.
The fact that £1 was obviously way below market rent, irrelevant.
Totally irrelevant to adequacy. The court isn't there to save you from a deal that just looks unequal in value.
Why not? What's the justification?
It comes back to that idea of freedom of contract. Parties should be free to decide for themselves what they value and what they'll accept in return. Lord Somerville in Sheppel v. Nestle, 1960, made this point. People might have hidden reasons for accepting seemingly low value.
Ah, yes. The Sheppel v. Nestle case. The chocolate wrappers for a record deal.
That's the one. Nestle offered discounted records to people who sent in postal orders plus 3 Nestle chocolate wrappers. The legal question was whether those wrappers were part of the consideration for the record.
Nestle probably hoped they weren't, maybe for copyright royalty reasons.
Likely, yes. They argued the wrappers were just a condition, a qualification to buy. But the House of Lords held the wrappers were part of the consideration.
Even though the wrappers themselves were basically worthless once used.
Yes. The key was that Nestle stipulated for them. They required customers to obtain and send them in. Why? To increase chocolate sales. That commercial motive showed the wrappers had value to Nestle in that context, even if no intrinsic value. So, the courts don't assess adequacy.
But this raises a bit of a puzzle, doesn't it? What about things that seem to have no economic value? Like in White v. Bluet, 1853.
Ah, good point. There, a son promised his father he would stop complaining about the father's distribution of property in his will in return for the father forgiving a debt the son owed him.
And the court said the son's promise wasn't good consideration.
Correct. The reasoning seemed to be that the son's promise, essentially not to annoy his father, lacked tangible economic value. It was too intangible.
So how does that square with the chocolate wrappers in Nestle, which also lacked obvious economic value? It feels a bit inconsistent.
It does seem inconsistent on the surface. Maybe the difference is that the wrappers were part of a clear commercial transaction, stipulated for a business reason, whereas the promise not to complain felt more like a domestic arrangement without clear value. The courts sometimes struggle with drawing this line, especially outside purely commercial deals. Cases like Ward v. Byam and Edmonds v. Lawson, mentioned in the activities, explore this value question further in different contexts.
Right, like whether a mother keeping a child happy has value beyond her basic duty.
Exactly, it's a nuanced area.
Okay, that sets us up perfectly for probably the most complex topic, existing obligations as consideration. This is where things get really interesting, especially for contract changes.
Yes, this is the big one. The core problem is, if you are already legally bound to do something, can performing that exact same duty count as fresh consideration for a new promise, usually a promise of extra payment?
My gut feeling, based on this something for something idea, is no. You're not giving anything new.
And that was the traditional view, but it's been seriously challenged and modified, leading to some real legal headaches. We need to break it down into 3 scenarios based on where the existing duty comes from.
Okay, scenario 1. Obligations arising under the law of public duty.
Think police officers, firefighters, witnesses summoned to court. The general rule is, performing a duty you're already required to perform by law is not good consideration for a promise of payment from a private individual.
Why not?
2 main reasons. First, technically, you're not giving anything extra, no new benefit or detriment. Second, and maybe more importantly, there's a public policy reason. We don't want public officials demanding extra payment just for doing their jobs. That could lead to corruption or unfair pressure.
The classic case is Collins v. Godfroy, 1831.
Exactly. A witness was subpoenaed, meaning legally required, to attend court. Someone promised to pay him for his trouble. The court said nope, he was legally bound to attend anyway, so his attendance wasn't consideration for the promise of payment.
Okay, but what if the official does more than their basic public duty requires?
Ah, that's the crucial exception. If you go above and beyond your public duty, that extra effort can be good consideration.
Like the police providing a special static guard during a strike in Glassbrook Bros Ltd v. Glamorgan CC, 1925.
Precisely. The colliery owner asked for a level of police presence, a garrison stationed at the mine that the police felt went beyond their normal duty to maintain order in the area. The House of Lords agreed that providing this requested enhanced service was consideration for the owner's promise to pay for it.
So it's about exceeding the standard duty. This is now often reflected in laws like the Police Act allowing charges for special services.
Right. Though figuring out exactly where that line is between core duty and doing more can still be tricky, as shown in the Leeds United football policing case. The court said policing streets around the stadium was still part of the core duty, not a chargeable extra.
And we also saw this with Ward v. Byam, where the court seemed keen to find the mother keeping the child well looked after and happy was more than her basic statutory duty, thus providing consideration for the father's promise to pay.
Yes, it shows a willingness sometimes to find that something extra to make a promise enforceable, especially in family context, perhaps.
Okay, scenario 2. Obligations owed under contract with a third party. This sounds a bit odd.
This one is actually more straightforward and well settled than the next scenario. The rule is performing, or even just promising to perform, a contractual duty that you already owe to Party A can be good consideration for a new promise made to you by Party B.
Wait, so if I'm contracted to sing at Alice's party, and Bob separately promises me £100 if I sing at Alice's party, my singing, which I already had to do for Alice, is consideration for Bob's promise.
Yes, exactly. You can potentially claim your fee from Alice and the £100 from Bob. Your performance of the duty owed to Alice also serves as consideration for Bob's promise.
So what am I giving Bob? I was going to sing anyway.
The legal thinking is either Bob is getting the benefit of the performance he wanted to see happen, you're singing, or you are incurring an additional potential detriment. You are now potentially liable for breach of contract to 2 people, Alice and Bob, if you fail to sing. That extra layer of legal exposure is seen as consideration moving from you to Bob.
Okay. Taking on double duty or double risk counts. What are the key cases?
Shadwell v. Shadwell, 1860, involved a promise to marry someone, then a binding contract with the fiancé, being consideration for an uncle's promise of an allowance. And the Eurymedon, in 1975, is a major one in shipping stevedores unloading goods, fulfilling their contract with the carrier, was held to be consideration for a promise from the cargo owner limiting the stevedore's liability. And Powon v. Lao Yulong, 1980, explicitly confirmed the rule. A promise to perform an existing duty owed to a third party is good consideration.
Right, so that's relatively clear. Existing duty to third party, good consideration. Now the really complex one, scenario 3. Obligations owed under a contract to the same contracting party. This is about changing the deal between the original two people.
This is where the fireworks are, legally speaking. The classic starting point is the old case of Stilk v. Myrick, 1809.
The sailors on the ship where some crew deserted.
That's the one. 2 sailors deserted mid-voyage. The captain couldn't easily replace them and promised the remaining crew they could share the deserters' wages if they worked the ship back home safely.
But when they got back, the captain refused to pay the extra.
And the court backed the captain. It held the sailors were already contractually bound to do everything necessary to get the ship back, including coping with normal emergencies like desertions. They hadn't done anything more than their original contract required. So performing that existing duty wasn't fresh consideration for the captain's promise of extra pay.
So the Stilk v. Myrick rule was harsh. Doing what you're already obliged to do for the other party gets you nothing extra.
Pretty much. Unless, like in a slightly later case, Hartley v. Ponsonby, 1857, so many crew deserted that sailing the ship became fundamentally different and much more dangerous. In that situation, the remaining crew agreeing to sail on was considered going beyond their original duty, providing consideration for extra pay.
Okay, so Stilk v. Myrick was the rule for a long time. But then came Williams v. Roffey, Bros and Nichols, Contractors, Ltd., 1991. This really shook things up.
Massively. So Roffey were main contractors renovating flats. They subcontracted carpentry to Williams for a fixed price. Williams underquoted and got into financial difficulty. They told Roffey they couldn't finish the job for the agreed price.
And Roffey was worried.
Very worried. Roffey had a penalty clause in their main contract if the whole renovation was late. If Williams stopped work, Roffey would be late and face penalties, plus the cost and hassle of finding new carpenters.
So Roffey offered Williams more money.
Yes. Roffey voluntarily offered Williams an extra payment per flat completed on time to ensure they kept working and finished the job. Williams did finish more flats, but Roffey then refused to pay the extra money, relying on Stilk v. Myrick.
Because Williams was just doing the carpentry they were originally contracted to do?
Exactly. Under Stilk v. Myrick, Williams finishing the job shouldn't have been consideration for Roffey's promise of extra pay, but the Court of Appeal disagreed.
What did they decide?
They held his promise. Roffey's promise was enforceable. They found that even though Williams was only doing what they were originally contracted to do, Roffey obtained a practical benefit from Williams actually completing that work, as agreed under the revised payment structure.
A practical benefit? What kind of benefits counted?
The court, particularly Glidewell L.J., pointed to several things. Roffey avoided the penalty clause in their main contract. They avoided the trouble and expense of finding substitute carpenters. They benefited from a more structured completion process, and they kept Williams working, hopefully finishing the job.
So the result of Williams doing their existing duty provided tangible advantages to Roffey, and that was enough.
Yes, that was the core idea. And crucially, the court emphasized that Williams hadn't secured the promise of extra pay through economic duress or fraud. Roffey offered it proactively because they saw a benefit in keeping Williams on the job. This suggests maybe Stilk v. Myrick was partly about preventing sailors from holding captains to ransom in emergencies rather than just a pure consideration point.
So the impact of Williams v. Roffey is huge for promises to pay more.
It is. It means performing your existing contractual duty can be consideration for a promise of extra payment from the same party if the promisor gets a practical benefit from that performance, and the promise wasn't obtained by duress. It makes it much easier to enforce variations where someone agrees to pay more for the same work, reflecting commercial reality, perhaps.
Glidewell L.J. set out some points for this, didn't he?
Yes, a kind of 6-point test. Existing contract for goods services. A doubts B will complete. B promises A extra payment. B obtains a practical benefit or obviates a disbenefit. B's promise not given under duress fraud. Then the benefit to B is capable of being consideration. Though later courts aren't strictly bound by that checklist, the practical benefit plus no duress elements are key.
Okay, Roffey helps when you promise to pay more for the same work. What about the opposite situation? Promising to accept less than you're owed. specifically part payment of a debt.
Ah, now we hit the real conflict zone. The long-established rule here comes originally from Pinnell's case, 1602, but was definitively confirmed by the House of Lords in Folks v. Beer, 1884.
And the rule in Folks v. Beer is
That part payment of a debt on or after the day the debt is due is not good consideration for the creditor's promise to forgive the remaining balance. So if you owe me £1,000 due today, and I say, okay, just give me £500 today and we'll call it quits, that promise from me isn't binding at common law. I can still come after you for the other £500 later.
even if I actually pay the £500, why isn't that consideration?
Because, legally speaking, you paying £500 is less than you were already obliged to pay, £1,000. The law doesn't see that as providing any new benefit to me, the creditor, or any new detriment to you, the debtor, that would justify me giving up my right to the full amount. You're just doing part of what you already had to do.
And Folks v. Beer itself involved Dr. Folks owing Mrs. Beer money from a court judgment. She agreed to let him pay the main sum in installments and promised not to pursue the interest that was legally due on the debt.
Yes, he paid off the main sum as agreed. Then she turned around and sued him for the interest.
And the highest court, the House of Lords, said she could.
Reluctantly, yes. They acknowledged it seemed harsh and maybe commercially unrealistic. Sometimes getting part of a debt paid is better than risking getting nothing. But they felt bound by the precedent from Pinnell's case and upheld the rule. Part payment isn't consideration for forgiving the balance.
Okay, so now we have this massive tension. Williams v. Rafi says a practical benefit, like avoiding hassle or penalties, can be consideration when you promise to pay more for the same work. But Folks v. Beer says a practical benefit, like getting some money now instead of maybe nothing, is not consideration when you promise to accept less to discharge a debt. They seem fundamentally inconsistent.
They absolutely do. And this clash came to a head in the case of MWB Business Exchange Ltd v. Rock Advertising Ltd 2016. This involved a tenant, Rock Advertising, who fell behind on their rent payments for office space licensed from MWB.
So a debt situation.
Exactly. They reached an oral agreement with MWB's credit controller to reschedule the payments, essentially paying less initially and deferring some amounts. Rock made the first payment under this new schedule. MWB then changed its mind, locked Rock out, terminated the license, and sued for the rent arrears based on the original agreement.
So Rock argued the rescheduling agreement was a binding variation. Did they argue MWB got a practical benefit?
They did. In the Court of Appeal, the judges, particularly Kitchen LJ, actually applying the Williams v. Rafi practical benefit reasoning to this part payment scenario. They said MWB did get practical benefits from the rescheduling agreement. They would recover at least some of the arrears immediately. They had hope of recovering all arrears eventually. And crucially, they kept the tenant in the property, avoiding the loss and cost associated with it standing empty.
Wow. So the Court of Appeal and MWB said a practical benefit could be consideration for accepting less, effectively challenging Folks v. Beer.
That's exactly what their reasoning suggested, yes.
Yeah.
It caused quite a stir because it seemed to pave the way for undermining the long-standing Folks v. Beer rule.
But what happened when it went higher? Did the Supreme Court agree?
No, and this is absolutely critical. The Supreme Court found a different way to decide the case. The original license agreement had a clause saying any variations had to be in writing and signed, a no oral modification or NOM clause. The Supreme Court focused on that, holding that the oral rescheduling agreement was invalid because of the NOM clause, regardless of whether there was consideration.
So they deliberately avoided ruling on the Folks v. Beer versus Rafi practical benefit conflict.
Completely. Lord Sumption explicitly said the consideration issue was difficult and should be reserved for an enlarged panel of the court in a future case where it was decisive. He acknowledged the arguments on both sides, but made no ruling.
So where does that leave us? Is Folks v. Beer still good law?
Technically, yes. The Supreme Court did not overturn Folks v. Beer. The Court of Appeals' reasoning in MWE about practical benefit applying to part payment is therefore not binding Supreme Court precedent. The highest court's word on part payment consideration remains Folks v. Beer. Yeah. It is not good consideration at common law. The tension remains unresolved.
So it's still uncertain if getting a practical benefit makes a promise to accept less binding at common law.
Exactly. And it's worth noting, as the source mentions, that Williams v. Rafi itself isn't without critics. A judge in SET v. Trafigura, 2004, questioned whether finding consideration in Rafi was really consistent with the rule that consideration must move from the promisee. It's a messy area.
Okay, let's recap the existing obligations minefield. 1, public duty, not consideration unless you do more. 2, duty owed to a third party. Yes, performing that is consideration for a new promise from someone else. 3, duty owed to the same party. Promise to pay more for the same work. Williams v. Rafi says yes, if there's practical benefit and no duress. Promise to accept less. Part payment of debt. Folks v. Beer says no consideration at common law. The MWB Supreme Court left the potential practical benefit argument unresolved here.
That's a perfect summary of a very tricky area.
Right. Let's move on to another way consideration can fail. Past consideration.
This one's generally more straightforward. The basic rule is consideration must be given in return for the promise. Something you did before the promise was even made cannot count as consideration for that later promise. It's past.
So the act wasn't done because of the promise. The promise came afterwards, maybe as a thank you?
Exactly. The classic example is Rima Cardle, 1951.
The decorating the family house case.
Yes. A daughter-in-law did significant improvements to a house that was part of an estate belonging to her husband and his siblings. After she had finished all the work, the siblings signed a document promising to reimburse her for the cost.
And when they didn't pay, she couldn't enforce it.
Correct. The court held the promise was unenforceable because the consideration she was relying on, the improvement work, was entirely in the past. It was completed before they made the promise to pay. The work wasn't done in exchange for that promise.
But sometimes people do work assuming they'll get paid later, even if the amount isn't fixed yet. Is there an exception?
Yes, there's a very important exception to the past consideration rule. This allows enforcement in certain circumstances where it looks like payment was implicitly understood all along. The test was laid out clearly by Lord Scarman in Powell on Vilau Yulong, 1979, building on older cases.
Okay, what are the conditions for this exception?
There are 3 conditions, and all must be met. 1, the act must have been done at the promiser's request. This links the act to the person making the later promise. It wasn't just a random act of kindness. The old case, Lamfley v. Braithwaite, 1615, fits here. Someone requested help getting a pardon, implying a reward would follow.
Okay, requested act. What's number 2?
2, the parties must have understood, at the time the act was requested, that the act was to be remunerated in some way, either by payment or some other benefit. There had to be an implicit understanding that it wasn't being done for free.
So it's an objective test. Would reasonable people in their situation have expected payment?
Yes. Think of Ree Casey's patents, 1892. Casey managed patents for the owners. It was clear for the circumstances he wasn't doing it for nothing. The expectation was he'd be paid. The later promise just quantified that expectation. This condition is often the hardest to prove.
And the third condition?
3, the promise of payment or benefit must have been legally enforceable if it had been made before the act. Basically, the later promise must satisfy all other requirements for a valid contract, like intention to create legal relations, certainty, etc. It can't be payment for something illegal, for instance.
So if you have a requested act, an understanding of payment at the time, and the eventual promise would have been okay if made earlier, then the promise made after the act can be binding.
Exactly. The later promise is seen as crystallizing the reward that was implicitly understood when the act was performed at request.
Let's try the activity example 3.13. Jack works late for his boss, Lisa, finishing a vital report. Lisa is thrilled and says later, "Great job, Jack. I'll add an extra 200 pounds to your pay this month." Can Jack enforce this?
Okay, let's apply the POW-ON test. 1, was the act, working late, done at Lisa's request? As his boss needing an important report, it's almost certain the work was done at her request, or at least under her implied direction. So, likely yes. 2, was it understood at the time that this extra work would be remunerated beyond his normal salary? This is the crunch point. Is working late occasionally just part of Jack's salary job? Or was this so exceptional, so above and beyond, that both sides would have implicitly understood it warranted extra pay? If extra hours are normally compensated in their workplace, yes. If everyone just works till the job's done, maybe no. It depends heavily on the context of their employment. 3, would a promise of 200 pounds for working late made beforehand have been enforceable? Yes. Generally, promising a bonus for specific extra effort is fine if agreed up front and supported by that effort as consideration.
So it really boils down to that second point, the shared understanding at the time.
Precisely. If a court believes there was an implicit understanding of extra reward when Jack stayed late, then Lisa's later 200 pounds promise is enforceable. Under the exception, it just fixes the amount. If not, it's just a gratuitous promise made after the event, falling foul of the past consideration rule like in Rima Cardle.
Okay, that exception is crucial. Good to remember those 3 conditions.
Now, let's shift to the other major doctrine for today, promissory estoppel. We've called it the equitable backstop.
Right. So, common law has these sometimes quite strict rules about consideration, especially for changing contracts. Why did equity feel the need to step in with promissory estoppel?
Because the common law requirement for new consideration every time you want to tweak an agreement could be really impractical and, frankly, sometimes unfair, especially in ongoing relationships or when circumstances change unexpectedly, like during a war. Equity, which aims for fairness, developed promissory estoppel to provide some flexibility.
So, it's about stopping people going back on their word when it would be unfair. It protects reliance.
That's the core idea, yes. It prevents a person from insisting on their strict legal rights when they have promised not to, and the other person has acted on that promise. Its origins can be seen in older cases like Hughes v. Metropolitan Railway, 1877.
Where negotiating about repairs suspended the original repair deadline.
Exactly. But the doctrine really took its modern shape and got its name widely known through Lord Denning's judgment in Central London Property Trust Ltd v. High Trees House Ltd, 1947. Arden L.J. later called it a brilliant decision.
The High Trees case is iconic. Can you remind us of the key facts?
Sure, a landlord company leased a block of flats in London to a tenant company just before World War II. During the war, because of bombing and low occupancy, the landlord agreed in writing to reduce the rent by half. The tenant paid the reduced rent for the war years.
Then, after the war, when the flats were full again.
The landlord wanted to return to the full original rent. They actually brought a test case concerning rent for the last part of 1945. Denning held they could claim the full rent going forward from when the conditions that led to the reduction, the war, had ceased. But crucially, he stated obiter, meaning it wasn't strictly necessary for the decision, but was an important statement of principle, that if the landlord had tried to claim the arrears, the full rent for the war years they had agreed to waive, they would have been stopped from doing so.
Even though the tenant hadn't given any consideration for the landlord's promise to accept less rent.
Exactly. Denning's famous statement was, "A promise intended to be binding, intended to be acted on, and in fact acted on, is binding so far as its terms properly apply." The promise to accept lower rent during the war was binding for that period because the tenant had relied on it.
Why was that considered so radical back then? Activity 3.14.
Because it directly challenged the fundamental common law principle that only promises supported by consideration are binding. It seemed to create a way to enforce promises based purely on reliance, which was a big departure. Denning himself argued it didn't destroy consideration, but supplemented it in specific situations, particularly modifying existing rights based on fairness.
How does it differ from other types of estoppel or waiver?
Well, traditional common law estoppel by representation only applies to misrepresentations of existing fact, like saying something is true when it isn't. It couldn't be used for promises about future conduct, like "I will accept less rent." Promissory estoppel does apply to these future promises. It also absorbed and expanded the older equitable idea of waiver, seen in Hughes, where parties could suspend rights by giving notice. But PE went further, potentially applying even to part payment of debt situations where waiver and common law struggled against Folk v. Beer.
Okay, so what are the ingredients needed for promissory estoppel to work? The requirements and limitations.
Kitchen LJ, in the MWB Court of Appeal case, gave a good summary. First, you usually need an existing legal relationship between the parties.
Typically a contract they are now modifying.
Yes. PE isn't generally a way to create a brand new contract out of thin air if there was never any consideration to begin with. That was established in Coombe v. Combe.
Second requirement.
A clear and unequivocal promise or representation by the promisor that they will not enforce their strict legal rights. It has to be unambiguous. It could be stated explicitly, like in High Trees, or implied by conduct, like in Hughes. If it's vague, PE might not apply.
Third, there must be reliance by the promisee on that promise.
Absolutely central. The person receiving the promise must have acted on it, changed their position in some way because of it.
Does the reliance have to be detrimental? Like, did they have to lose something?
That's debated. Lord Denning argued in W.J. Allen & Co. v. L. Nisner that detrimental reliance isn't strictly necessary. What matters more is that the promise acted on the promise in such a way that it would now be inequitable, unfair for the promiser to go back on their word. That inequity is the key. Goff J. in the Postchaser echoed this reliance makes it inequitable to resile. The High Trees tenants relied by managing their business, assuming lower rent.
Okay, inequitable reliance. What's the fourth really crucial limitation?
It can only be used as a shield, not a sword. Meaning promissory estoppel is primarily a defense. It protects the promisee from the promisor trying to enforce the original rights they promised to waive. It cannot be used by the promisee as the basis for a new lawsuit to enforce a promise for which they gave no consideration.
So the high tree's tenants could use it to defend against a claim for back rent, but they couldn't have used it to sue the landlord to force them to accept lower rent if the landlord had never lowered it in the first place.
Exactly. That's the principle from Combe v. Combe. A husband promised his estranged wife an allowance, but didn't pay. She couldn't sue him based on promissory estoppel because she had given no consideration for his promise. PE couldn't create a cause of action for her. Consideration is still needed to form a contract, but PE can sometimes prevent insistence on original terms when modifying or discharging one. English courts have strongly resisted using PE as a sword, unlike some other jurisdictions like Australia.
Fifth requirement. It must actually be inequitable for the promisor to go back on the promise.
Yes, because it's equity. It's about fairness and conscience. The judge has discretion. Even if there's a clear promise and reliance, if it doesn't seem unfair for the promisor to change their mind, PE won't apply.
When might it not be inequitable?
The classic example is if the promise acted badly to get the promise. In D&C Builders v. Rees, Mrs. Rees knew the builders were desperate for money. She offered them much less than they were owed, saying, "Take it or get nothing." They reluctantly agreed. Later, they sued for the balance. The court said PE didn't protect Mrs. Rees because she had used undue pressure. Her conduct made it not inequitable for the builders to go back on their promise.
So, clean hands are needed.
Pretty much. Also, if the promisor withdraws the promise quickly, giving reasonable notice, and the promisee hasn't really suffered any disadvantage from their brief reliance, it might not be inequitable to allow the withdrawal, the post-chaser.
And the final point, the effect is generally suspensory.
Yes, usually. PE typically suspends the promisor's original legal rights, rather than extinguishing them forever. This means the original rights can often be revived. Sometimes they revive automatically when the reason for the concession ends, like the war ending in high trees. Other times, the promisor can revive their original rights by giving reasonable notice to the promisee. Tool Metal Manufacturing Co., Ltd. v. Tungsten Electric Co., Ltd.
But for the period the estoppel was actually operating, the rights are usually extinguished, right? The high tree's landlord couldn't claim the waived rent for the war years.
Correct. Generally, the promisor cannot claw back payments or performance that were waived during the period the estoppel was effective. So it can be extinctive for that specific period, even if suspensory going forward. Although, remember that slight uncertainty raised by the MWBCA about whether it extinguishes the right to the balance of a specific part payment installment.
Okay, so PE needs an existing relationship, clear promise, reliance, making it inequitable to go back, used as a shield, generally suspends but can extinguish past rights.
That's a very good summary of the key elements. It's equity's way of injecting fairness when strict common law consideration rules would lead to injustice.
Which brings us back to that question from Activity 3.15. Given that Williams v. Rafi makes it easier now to find consideration for variations, the practical benefit idea, do we still need promissory estoppel?
Oh, absolutely. Yes, they cover different ground. Rafi primarily helps where someone promises to pay more for the same or more work. Promissory estoppel is still vital for promises to accept less, like part payment of debt. Remember, under Folks v. Beer, there's no consideration at common law for accepting less, and the Supreme Court in MWB didn't resolve whether Rafi's practical benefit applies there.
So PE is often the only hope for the debtor in that situation.
It often is, yes. It provides a potential defense based on reliance and equity when the common law of consideration offers no help. Plus, PE focuses on the inequity of going back on a promise after reliance, which might apply even if a practical benefit under Rafi is hard to pinpoint. Or maybe even if there were issues like slight pressure that might block Rafi, but not necessarily PE if the overall situation is still inequitable. They operate differently.
Right. Rafi is common law consideration, practical benefit. PE is equity, reliance, and fairness, both needed for different modification scenarios.
Exactly.
Okay, brilliant. We've got the theory down. Let's try and pull it all together by looking at that sample problem question from the source material. Simone the landlord, Peter the electrician. This feels like a classic exam-style scenario.
It really does. These questions are designed precisely to test if you can spot the different legal issues arising from a sequence of events formation. Variation 1, more money. Variation 2, more money for deadline. Variation 3, accepting less. And apply the right doctrines, including the tricky bits like Rafi, Folks v. Beer, and PE.
Okay, so the basic setup. Simone hires Peter to rewire 5 houses for £5,000 total, completion by end of August. Standard contract, presumably binding.
Yes, looks like a straightforward executory contract. Promise for a promise, supported by consideration on both sides.
Issue 1. Peter hits snags, materials cost more, he tells Simone. Simone, anxious for completion, agrees to pay an extra £500 to help with materials. Is this £500 promise binding?
All right, so Peter needs consideration for this extra £500. Simone's argument would be, Peter was already obliged to do the rewiring, including providing materials, for the original £5,000. He's just doing his existing duty. Under Stilp v. Myrick, no new consideration, so the £500 promise isn't binding.
But Peter's counter-argument is Williams v. Rafi.
Exactly. He'd argue Simone received a practical benefit. By promising the extra £500, she ensured he could continue the work without delay, avoided the hassle of finding someone else mid-job, and increased the chances of timely completion, which she was anxious about.
Let's check the Rafi factors again. Contract for services, yes. Peter having difficulty, yes. Cost. Simone promises more, yes. £500. Simone gets practical benefit, yes. Continued work avoids delay hassle. Duress. Doesn't seem like it Peter explained. Simone agreed because she was anxious.
Based on that analysis, it seems highly likely that under Williams v. Rafi, Simone's practical benefit is good consideration for the £500 promise. The variation seems binding.
Okay, variation 1 likely enforceable. Now, issue 2. Later, Simone gets really worried about a September 15th deadline for student tenants. The original deadline was end of August. She offers Peter another £1,000 if he can guarantee completion by September 15th. He agrees. Binding.
So Peter is promising to meet a new deadline, September 15th, which is actually later than the original one, but it's a deadline that has become critically important to Simone. Again, is there consideration for her £1,000 promise?
Seems like another Williams v. Rafi situation. Simone is promising more money. Does she get a practical benefit?
I'd say definitely. Getting the houses ready specifically for the September 15th student arrivals is a huge practical benefit for her. It avoids lost rent, avoids the nightmare of potentially having to find alternative accommodation for tenants, secures her income stream. This benefit flows directly from Peter meeting that specific crucial deadline.
And duress. Again, Simone is the one initiating this, driven by her own needs. Peter just agrees.
Right. So applying Williams v. Rafi, the significant practical benefit to Simone seems like good consideration for the £5,000 promise. Both the £500 and £1,000 variations look likely to be binding.
Which means the total amount Peter is legally owed upon completion by September 15th is £5,000 plus £500 plus £1,000 plus £1,000 is £6,500.
Correct, assuming those variations hold up under Rafi.
Now for the final twist, issue 3. Peter finishes by September 15th. He's owed £6,500. Simone tells him she's having financial difficulties and asks if he'll accept £5,000 in full settlement. Peter reluctantly agrees and takes the £5,000. Can Peter now change his mind and sue for the remaining £1,500?
This lands us squarely back in the part payment of debt territory. Peter has agreed to accept less £5,000 than he's legally owed, £6,500.
So the starting point is Folks v. Beer.
Absolutely. The common law rule from Folks v. Beer is that Simone's payment of £5,000 is not good consideration for Peter's promise to forgive the £1,500 balance. She's just paying less than she owes. So, based on common law alone, Peter's promise isn't binding, and he can sue for the remaining £1,500.
Could Simone try the MWB Court of Appeal practical benefit argument here? Argue that Peter got a practical benefit by receiving £5,000 immediately without having to chase her for the full amount.
She could try that argument, yes. The NWBCA suggested such benefits might suffice. However, we must remember the Supreme Court in MWB deliberately didn't endorse this for part payment. They left Folks v. Beer standing as the highest authority on this specific point. So, relying purely on common law considerations, Simone's defense looks very weak.
Okay, so common law probably doesn't help Simone. What about equity? Can she use promissory estoppel as a defense, as a shield against Peter's claim?
This is her best shot. Let's run through the PE checklist. 1. Existing legal relationship. Yes, the modified contract for £6,500. 2. Clear promise. Yes, Peter clearly promised to accept £5,000 in full settlement. 3. Reliance. Yes, Simone relied on this promise by actually paying the £5,000. 4. Inequitable to go back. Now, this is the killer point. Would it be unfair for Peter to demand the extra £1,500 now? Here, that extra fact from the source becomes crucial. Peter later found out Simone's financial problems were less serious than she made out.
So if she exaggerated or misled him about her finances to get him to agree.
Then DNC Builders v. Rees becomes highly relevant. If Simone used deception or unfair pressure, equity likely won't assist her. It would not be inequitable for Peter to go back on a promise obtained improperly.
But what if she didn't exactly lie, but maybe just painted a gloomy picture? Or if she was genuinely struggling, just not quite as badly as implied?
Then it becomes much more debatable. If her difficulties were real, even if exaggerated, and Peter agreed, even reluctantly, and accepted the £5,000, a court might find it inequitable for him to renege later. Promissory estoppel can apply to part payment situations to prevent the creditor demanding the balance if the circumstances make it fair to do so. Remember High Trees and the comments in Collier v. Wright suggesting PE could help debtors.
So the inequitable part is really fact-sensitive, especially regarding Simone's honesty about her finances.
Absolutely. That could be the deciding factor on whether PE provides her with a defense.
So the overall conclusion for Peter:
Advise Peter that he is likely owed the full £6,500 based on the variations being supported by practical benefit under Williams v. Roffey. Simone's part payment of £5,000 is, at common law under Folks v. Beer, not sufficient consideration for his promise to waive the £1,500 balance. Therefore, at common law, he can likely claim the remaining £1,500. However, Simone may have a defense in equity using promissory estoppel, arguing it would be inequitable for him to go back on his promise after she relied on it by paying £5,000. The success of this defense is uncertain and depends heavily on the facts, particularly whether Simone misled him about her financial state. If she did, her defense will likely fail at D&C Builders v. Rees. If she acted in good faith, she has a better chance.
Wow, that problem question really does tie everything together: the common law rules, the exceptions, the tensions, and the role of equity.
It shows how you need to navigate between consideration and promissory estoppel, understanding where each applies and how they interact, especially with those unresolved questions around Roffey and Folks.
Well, we have certainly covered a huge amount of ground today. We started right back with the core idea of consideration, that essential exchange needed for a binding contract in English law.
We looked at the difference between sufficiency, which matters, and adequacy, which doesn't, using cases like Thomas v. Thomas and Chappelle v. Nestle.
Then we dive into the really complex world of existing obligations. Public duties generally don't count unless you do more. Duties to third parties generally do count.
And the big one, duties to the same party. The old Stilk v. Myrick rule, no consideration, was modified by Williams v. Roffey. Practical benefit can be consideration for more pay if no duress. But the rule for part payment of debt, Folks v. Beer, no consideration for accepting less, remains problematic, with the MWB cases leaving the practical benefit argument unresolved there.
We also covered past consideration generally not valid, with Ray McArdle as the example, but remembered the crucial three-part exception from Pow on.
And finally, we explored promissory estoppel, stemming from High Trees. We saw its requirements, existing relationship, clear promise, reliance, inequity, and its key limitations, especially being a shield, not a sword, and its generally suspensory effect.
Understanding these two doctrines, consideration and promissory estoppel, is just fundamental. They really determine when promises become legally enforceable and when changes to those promises stick.
We really hope this discussion, drawing on those excellent University of London materials, has helped clarify these concepts. Again, huge thanks to the university for making them available for educational use.
And one more time for all of you students listening, perhaps with exams on the horizon, truly the very best of luck from both of us.
This deep dive was brought to you by Sinorbit Academy, Sri Lanka.
So, as we wrap up, here's a final thought to chew on, building on everything we've discussed. There's this constant tension in contract law, isn't there, between the need for clear, predictable rules like the traditional consideration requirements, which give certainty, and the desire for fairness and flexibility, which doctrines like Williams v. Roffey, with its practical benefit, and promissory estoppel, with its focus on inequity, try to provide.
It's a real balancing act. Does embracing concepts like practical benefit make the law more realistic and fit for the commercial world? Or does it just muddy the waters, making it harder for businesses and individuals to know for sure if their agreements, especially variations, will hold up in court?
Where should that balance lie? How much should the law prioritize the certainty of exchange versus preventing unfair outcomes based on reliance? It's something worth pondering as you continue to explore the fascinating world of contract law.
Definitely food for thought. Keep questioning.
That's all for this deep dive. Thanks for listening.